Pam, I have a clear and simple message for you. The way this administration, and you specifically, have handled survivors has been nothing short of a failure.
The people who had the authority to intervene chose silence, secrecy, and self-preservation and called it justice. I'm here to make sure no one in the Justice Department, no matter their title, rewrites history or escapes accountability.
This time, it isn't a monster pedophile who is doing the exploiting, but our very own government.
Welcome to this prosecutorial analysis. Today, we examine the conduct of the Attorney General of the United States. We will look at her testimony before the House Judiciary Committee. We have the official records. We have the transcripts. We have the statements made by legal experts and the victims who sat directly behind her. We will apply strict forensic scrutiny to the claims made under oath. We will not look away from the facts. We will trace every factual claim back to the source material. We will evaluate the evidence. We will apply the law. We will demand accountability. This is not commentary. This is not entertainment. This is the exact record of what happened in that hearing room. Here, play this clip.
We've been watching a congressional hearing erupt into shouting matches. Attorney General Pam Bondi has been defiant and explosive as she fields questions from members of the House Judiciary Committee, and it's happening on multiple fronts and multiple controversies, including the Justice Department's release of the Jeffrey Epstein files. First, just watch this exchange with Democratic Congresswoman Pramila Jayapal.
It is about you taking responsibility for your Department of Justice and the harm that it has done to the survivors who are standing right behind you and are waiting for you to turn to them and apologize for what your Department of Justice has done.
We will analyze the power dynamics. We will look at the institutional failures. We will not deviate from the established facts. We will not offer opinions disguised as evidence. We will trace the line from the spoken word to the documented truth. We will look at the exact quotes. We will look at the exact reactions of the people in the room. We will begin with the most critical factual dispute of the day. We must make an opening judgment. We must identify a false claim by a linked authority. The linked authority here is Attorney General Pam Bondi. She is the top law enforcement officer appointed by this administration. Pam Bondi claimed that the Department of Justice removed the identifying information of Jeffrey Epstein survivors from public files if those survivors contacted the department. That is a lie. That statement is factually false. It was demonstrably false at the exact moment she spoke those words into the congressional microphone. Here, play this clip.
There was also this moment when Congresswoman Jayapal asked Jeffrey Epstein survivors who are in the room to raise their hands if they haven't been able to meet with the Justice Department. Every one of them raised their hands. Now, Bondi did acknowledge in her opening statement the victims, and she said she's deeply sorry for what they've been through and that the FBI wants to hear from them. Over the last 2 hours, it has been very clear that the Attorney General was speaking to an audience of one.
She presented this false claim to defend her department. She presented this false claim to deflect criticism. That is a lie. We must define the lie precisely. We must quote the exact claim. We must identify the speaker and the authority. The speaker is Pam Bondi. The authority is her position as the Attorney General of the United States. During a combative hearing before the House Judiciary Committee, Pam Bondi made a direct, factual assertion regarding the Department of Justice and the release of the Jeffrey Epstein files. Lisa Rubin reported on this specific statement. Pam Bondi said that if Jeffrey Epstein survivors contacted the Department of Justice and told them that their identifying information had been included in this release, the information had been taken down. Here, play this clip.
So, Brendan, I want to play part of an exchange with Jerry Nadler when he was asking her again about the Epstein survivors, and Bondi again refused to answer.
How many of Epstein's co-conspirators have you indicted? How many perpetrators are you even investigating?
First, you showed it. I find it.
How many have you indicted?
Excuse me. I'm going to answer the question.
Answer my question.
No, I'm going to answer the question the way I want to answer the question.
No, you're going to answer the question the way I asked it.
She claimed the Department of Justice removed the sensitive identifying data of the victims once they were notified. This claim was broadcast to the American public. This claim was made while the victims themselves were sitting right behind her in the hearing room. This claim was delivered as a defense of her department's handling of the Epstein files. It was presented as a statement of administrative fact. It was presented as an action already completed by the federal government to protect survivors of sexual exploitation. She stated this as a matter of record. She used the authority of the Justice Department to legitimize this claim. She expected the committee to accept this claim without verification. She expected the public to believe that the Department of Justice had successfully protected these victims after an initial error. The claim is absolute. The claim is specific. The claim is false. We now turn to the forensic evidence. We rely strictly on the documented record. The forensic evidence proves that Pam Bondi's statement is false. The forensic evidence does not prove her state of mind. It does not prove whether she intentionally perjured herself or was simply misinformed. Pam Bondi may believe what she said was true, but the objective evidence proves the statement itself is not true. Let us look at the findings of Lisa Rubin. Lisa Rubin is an MSNBC senior legal reporter. She conducted a direct search of the Epstein files on the Department of Justice's own website on the very morning of the hearing. That search yielded forensic proof. Multiple survivors are represented by quality, competent counsel. Here, play this clip.
Separately. Well, let's talk first about the truth or falsity of what Pam Bondi said this morning. Pam Bondi may believe what she said was true, but I can tell you, based on a search of the Epstein files this morning on the department's own website, it's not true. I know multiple survivors who are represented by quality, competent counsel who have told me they have been in touch with the Department of Justice on behalf of clients, and multiple survivors' names are still in the files as we speak today. And they are in the files not just with respect to unredacted court documents, for example, but email exchanges and the like, the sort of documents that were supposed to be redacted from the get-go.
Those attorneys have been in direct touch with the Department of Justice on behalf of their clients. They contacted the Department of Justice to protect their clients. Despite this contact, multiple survivors' names were still in the files as the hearing took place. The evidence proves exactly where this information remains. The names are not just in unredacted court documents. The names and identifying information are also located in email exchanges. These are the exact sort of documents that were supposed to be redacted from the very beginning of the release process. The evidence proves the Department of Justice failed to redact this information initially. The evidence proves the Department of Justice failed to remove this information after being notified by the victim's counsel. The evidence proves the names remain accessible on a federal government website. We also have the public record of the hearing itself. During the hearing, Democratic Congresswoman Pramila Jayapal directly confronted the Attorney General. Congresswoman Jayapal asked the Jeffrey Epstein survivors who were present in the room to raise their hands if they had not been able to meet with the Justice Department. Every single one of the survivors raised their hands. The evidence proves the Department of Justice has not met with these victims. The evidence proves the victims physically demonstrated this failure in the hearing room. We have the public testimony of the survivors who sat through the hearing. Before the hearing, a survivor delivered a clear message to Pam Bondi. The survivor stated that the way this administration and Pam Bondi specifically have handled survivors has been nothing short of a failure. The survivor stated that the people with the authority to intervene chose silence, secrecy, and self-preservation and called it justice. The survivor stated that the government itself is doing the exploiting this time. The public record further proves the Attorney General's absolute refusal to address the victims. The public watched the hearing. The public saw her physical reactions. The public documented her behavior. Viewers noted she was nervous and flipping papers, avoiding eye contact. Viewers noted she was shuffling papers to avoid being seen shaking. Viewers noted her body language showed no direct eye contact, flipping through papers aimlessly, and avoiding looking senators in the face. The public documented that she had nothing to say to the survivors behind her. All of those survivors reported the crimes committed against them with no response. Yet the Attorney General claims she spoke to everyone who came forward. The public documented this contradiction. The evidence proves the victims feel exposed. The evidence proves the victims feel abandoned by the Department of Justice. The evidence does not prove how the original error occurred. The evidence does not prove the specific internal chain of command that led to the unredacted release. The evidence only proves that the Attorney General claimed the files were scrubbed upon request, and the files were in fact not scrubbed. The evidence proves the victims remain exposed. We must analyze the dynamics of power and control. We must examine how power was deployed for every piece of evidence. The Attorney General holds immense power. The victims hold very little power. The Department of Justice controls the files. The Department of Justice controls the website. The Department of Justice controls the redaction process. The victims can only request protection. They cannot enforce it themselves. When Pam Bondi testified, she used her power to deflect accountability. She spoke to an audience of one. She performed for the president. This is an exercise of political power over legal responsibility. When asked direct questions about Jeffrey Epstein, she used her power to change the subject. She pivoted to talking about the Dow Jones Industrial Average. She stated the Dow was over 50,000, and that is what they should be talking about. The Dow Jones is not under the authority of the Attorney General. This was a deliberate control tactic. It was an assertion of power to dictate the terms of the hearing. When challenged by Democratic members, she deployed opposition research. She arrived prepared with a binder filled with bullet points on each member. This is an aggressive use of institutional power. When a member asked a hostile question, she lobbed an accusation against them. She accused Zoe Lofgren of taking campaign contributions from Reid Hoffman, a Silicon Valley billionaire. Zoe Lofgren denied this, stating it was not true. This tactic is not designed to answer questions. It is designed to control the narrative. It is designed to intimidate the questioner. She used her power to insult the committee members directly. She called them hypocrites. She called them a joke. She told members that they should be apologizing to Donald Trump for participating in the impeachment hearings against him. She accused a member of having Trump derangement syndrome. She called a member a failed politician. She called a member a loser lawyer and stated they were not even a lawyer. This is not the standard behavior of a cabinet officer. This is the deployment of raw political power to crush oversight. The public recognized this control tactic. The public identified it as the Roy Cohn playbook, which is to admit nothing and attack. The public identified her behavior as weaponized pearl clutching, used as a tool of deflection and obstruction. She used her power to ignore the victims. The victims were sitting right behind her. She refused to turn around and confront them. She was asked by Congresswoman Jayapal to turn to the survivors and apologize for what the Department of Justice had done. She refused. She stated she would not get in the gutter for theatrics. This is a profound abuse of power. The top law enforcement official in the country refused to look at the victims of a massive sex trafficking operation. She controlled her physical space to deny them acknowledgement. We must also look at the power dynamics regarding the Republican members of the committee. Many Republican members expressed outrage during the hearing, but their outrage was not about the Epstein victims. Their outrage was about their own phone records. They were upset that their phone numbers had been collected during the Arctic Frost investigation. That was the investigation that eventually became Jack Smith's case regarding fake electors and election interference. The Republican members felt their own civil rights and privacy were violated. They complained about this without any self-awareness. They complained about their phone records while the women victimized by Jeffrey Epstein and Ghislaine Maxwell sat right behind the Attorney General. The members used their power to focus on their own minor privacy concerns. They ignored the massive privacy violations committed by the Department of Justice against the Epstein survivors. This shows a complete self-absorption of power. The people with power protected themselves. The people with power ignored the vulnerable. The people with power traded insults and demanded apologies while actual victims sat in the room asking for basic competence. We must present the strongest defense argument for the Attorney General. We must present it fairly. We must then dismantle it using the law and the sources. The strongest defense argument is twofold. First, the defense argues that the Attorney General cannot and should not comment on ongoing investigations. Brendan Ballou, a former federal prosecutor, stated that it is not surprising and actually appropriate for the Attorney General not to name or say how many people related to Jeffrey Epstein are under investigation. The Department of Justice does not comment on ongoing investigations for good reasons. Second, the defense argues that the Attorney General did acknowledge the victims in her opening statement. She said she is deeply sorry for what they have been through. She said the FBI wants to hear from them. She also made a pledge to Congressman Eric Swalwell. Swalwell discussed the threats to his family resulting from past investigations. The Attorney General calmly pledged to brief him off camera and stated that no one should face threats to their family's safety. The defense argues she is following protocol and showing appropriate concern where permitted. We must provide legal education in plain English. We must understand the rules that govern these proceedings. We must understand the legal obligations of the Department of Justice. First, we must understand the role of a congressional hearing. A Congressional Oversight Committee has a constitutional duty to oversee executive agencies. The House Judiciary Committee is an oversight committee for the Department of Justice. When a member of Congress asks a cabinet official to submit a document, the legal and constitutional answer must be yes. The official cannot refuse simply because they do not like how the questions are being asked. Refusing to answer legitimate oversight questions undermines the constitutional structure of our government. The Attorney General stated she would not commit to anything because she did not like how the questions were being asked. This is not a plausible option for a cabinet official. Second, we must understand the Administrative Procedure Act. This is a federal law. It governs the process by which federal agencies develop and issue regulations. It also provides a way for citizens to sue the government if an agency is not following the law. The current administration is not in compliance with the Epstein Transparency Act. Brendan Ballou explained that getting the administration into compliance will not happen through hearings. It will happen through litigation. It will likely require a lawsuit under the Administrative Procedure Act. This is the only way to get independent oversight over the production of documents. This is the legal mechanism to force the government to obey the law. Third, we must understand the concept of redaction. Redaction is the legal process of censoring or obscuring part of a text for legal or security purposes. When the government releases court documents or emails, it has a legal duty to protect the identities of victims. Unredacted documents expose victims to harm. The Department of Justice failed in this fundamental legal duty. They released unredacted court documents and unredacted email exchanges. This violated the privacy and safety of the survivors. This is not a clerical error. This is a legal failure. Fourth, we must understand the presumption of regularity. This is a vital legal principle. It is the belief that government officials will perform their duties honestly and in accordance with the law. It is the belief that the Department of Justice will tell the truth. The conduct of the Attorney General in this hearing damages that presumption. When the top law enforcement official makes demonstrably false claims about redactions, the presumption of regularity is broken. The public documented that this belief is dead and gone. When the Department of Justice is seen as a partisan instrument of power rather than a neutral arbiter of justice, the legal system suffers. The law requires trust. The law requires facts. This hearing provided neither. We now deliver a professional judgment on responsibility and fitness. This judgment is based strictly on the documented behavior. This is not about politics. This is about the fitness required to hold the office of the Attorney General of the United States. The Attorney General is the top law enforcement official in the country. This is the job once held by Robert F. Kennedy Sr., Elliot Richardson, and Janet Reno. It requires a higher calling. Modern attorneys general have traditionally understood they are not just political actors. They are there to represent justice in a broad sense. They are not there just as the personal attorney for the president. We support this analysis with an expert authority stack. These are the credentialed professionals who provided the evidence and context. We have Lisa Rubin. She is an MSNBC senior legal reporter. She directly investigated the Department of Justice website to verify the presence of unredacted victim names. We have Brendan Ballou. He is a former federal prosecutor. He is a former attorney with the Department of Justice's National Security Division. He provided the analysis on the Administrative Procedure Act and the devastating impact this hearing has on the credibility of line-level prosecutors. We have Peter Baker. He is the New York Times chief White House correspondent and an MSNBC contributor. He provided the historical context of the Attorney General's role and the unprecedented partisan nature of Bondi's behavior. We have the public record of Representative Jerry Nadler, asking detailed questions regarding the number of indicted co-conspirators. We have the public record of Representative Pramila Jayapal confronting the Attorney General regarding the victims in the room. We have the public statements of the Epstein survivors themselves, who stood as living proof of the department's failure. We have the public condemnation of citizens who watched the hearing and documented the failures. They provided real-time documentation of the Attorney General's hostile posture. They noted the weaponization of the process. They noted the moral collapse demonstrated in the room. These are not isolated opinions. This is the compiled record of observation. These authorities build an immovable wall of fact against the Attorney General's testimony. We must examine institutional accountability. We must look at the failures of the Department of Justice, the courts, and the enforcement mechanisms. The Department of Justice has failed fundamentally. The department failed to secure indictments against 6 Democratic elected officials recently. The department has experienced any number of failed indictments in the District of Columbia. The department has faced dozens of judges across the country who have found that this specific Department of Justice lacks credibility. The department's reputation is in ruins. The Department of Justice must go to court all over the country every single day. They have to argue for this administration. When the Attorney General behaves this way on television, it has a direct impact on line-level prosecutors. The credibility of those prosecuting attorneys washes away. They suffer one loss after another on extraordinary matters because the institution is seen as a partisan instrument. The institution failed to protect the Epstein victims. The institution failed to redact the documents. The institution failed to meet with the victims. The institution released evidence used to get a search warrant in Fulton County, Georgia, based on conspiracy theories. The institution is involved in a lawsuit with 24 states trying to get sensitive personal information on voters. We conclude with procedural consequences only. We deal only in the concrete steps that must follow. We do not offer hope. We do not offer hype. The Attorney General will not change her behavior based on this hearing. The administration will not come into compliance with the Epstein Transparency Act voluntarily. The procedural consequence must be litigation. A lawsuit must be filed under the Administrative Procedure Act. This lawsuit will compel independent oversight over the production of documents. This is the only procedural mechanism available to force compliance. The victims represented by competent counsel will continue their legal engagement with the Department of Justice to force the removal of their identifying information from the unredacted court documents and emails. The Department of Justice will continue to face skepticism from federal judges across the country. Line-level prosecutors will continue to carry the burden of the Attorney General's damaged credibility into every courtroom. The public record of this hearing will stand as the official documentation of the executive branch's refusal to answer congressional oversight questions. The transcripts are fixed. The failure is logged. The legal process moves forward. There are no political solutions offered here. There are only legal filings. There are only court dockets. The Department of Justice must answer to the judicial branch. The Administrative Procedure Act remains the sole remaining avenue for the victims. The failure of the hearing means the courts must take over. The record is now complete.